2015 CR 12154, State of Texas versus Stephen Allen Salinas. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense.
Robert Gear, Your Honor, for defendant Stephen Salinas, and we are ready.
And are you Stephen Salinas?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I did.
Are you the same Stephen Allen Salinas who's placed on deferred adjudication in 2015 CR 12154 for the offense of continuous violence against family on March 16, 2016 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 19th day of October 2020 in Bexar County, Texas. The defendant, Stephen Allen Salinas, did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
How do you plead to that? True or not true?
That's true.
State.
The state will waive and abandon the other allegations.
Any objection?
No objections from defense, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation?
This is where everything is on the line. One answer, and his entire future could disappear. And the crazy part? He already knows the risk and still says yes.
So it is to revoke the defendant's community supervision, to sentence the defendant, to adjudicate the case and sentence the defendant to 2 years in the Texas Department of Corrections and give him credit for any time he's already served.
All right, why should I sentence him to the minimum? Has he done anything on probation?
Yes, Judge. May it please the court. Defendant was charged with continuing violence. He did attend and complete the BIP course in this matter to address that. There was also some allegations of drug use.
Just 1 second.
Sorry.
All right, you may continue.
Yes, Judge, sorry. In addressing the alleged drug use, he did attend and complete the BEAR outpatient program in this matter. Because of these charges, there was also CPS intervention with the.
Why are you crying?
Because I lost my son.
In what way did you lose your son? Did he pass?
No.
All right.
Because of this.
All right, so you lost your son because you didn't do what you were supposed to do. That's what these are called consequences.
I know.
And just like that, this stops being about drugs or probation. Now it's about something much deeper. Because losing your child, not to death, but because of your own actions, that's a pain that doesn't go away.
117 hours of community service in this matter, Judge. The one allegation of drug use was from October of 2020. Judge will look at the back page. From then until he was expired in March, there was a whole page full of negative tests between then and the expiration of his probation.
Here's where things get complicated. Because yeah, he messed up. But he didn't just give up either. He actually tried to fix his life. And that matters more than people think.
Required to do, including the classes, the community service hours, and tending to the issues made the basis of this case. Thank you.
All right, state, why should I follow this agreement?
Your Honor, I would echo what defense said, because he completed many of the terms on probation, drug treatment, and at the end of his probation, he was providing negative drug tests on his UAs.
All right, probation, is there anything you wish to say?
Your Honor, the case expired in 2021, so we're past the year mark, jurisdiction, and so forth. The recommendation from probation is to revoke or terms unsatisfactory if the balance is paid in full.
All right, so you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and state your name for the record.
As Stephen Salinas.
All right, Mr. Salinas, So what happened with your CPS case?
Well, like,
Were your rights terminated?
yes, ma'am,
And was your son adopted out?
he was.
Is it to people you know or not know?
I mean, it's to her family, but it's hard to see him.
All right.
You can hear it in his voice. This isn't someone arguing. This is someone dealing with the consequences. And maybe hoping it's not too late to change something.
I mean, October of 2020, I really don't do anything. I go to work. I mean, I drink beer after work, but that's about it.
Can't be drinking beer because that causes slip up. Don't change one addiction for another.
Yes,
It's sort of,
ma'am. Yes, ma'am.
when I see a lot of people in treatment, guess what? They don't use cocaine or whatever anymore, but they chain smoke. So
That right there? That's real. A lot of people think quitting one thing is enough, but replacing it with something else just keeps the cycle going.
But I've been a technician for Sun Auto for about 3.5 years, and then the last couple months I've been self-employed as a mobile mechanic.
okay.
On top of that, I was just about to go to college and everything before I got picked up. And I did check to see if there was a warrant to take care of this, but
But I mean, did you think this was just going to go away?
I mean, I didn't know what happened after, just after my PO told me that probation was over, and then when it came time for just for me to get my ID, that's when I was calling in to see if I had a warrant to take care of all this, and I would have been here sooner.
All
So
right.
now
and are
the
you still
question
in-
is simple. Do you punish the mistake or reward the progress? Because the law sees the violation, but the judge sees the whole story.
Is there any other questions from either side?
Nothing further from defense, Your Honor.
Well, it appears that he completed all of the conditions that were asked of him. It appears that he hasn't picked up any new cases. Am I right?
That is correct. Your
And the cocaine positive UA is from 2020.
You are correct, Your Honor.
And so we're in 2023 now.
That's correct.
And so is there any suspicion that he has used beyond that 2020 date from either side?
State has no evidence of that.
Judge, from defense, we have no suspicion. I know from chatting with him, he's been employed, gainfully employed. And I would assume that continuously gainful employment would negate the use and the consequences that stem from that, Judge.
All right, this is what the court is going to do. The court is finding violation condition number 2 true. There is to be no contact with Savannah, Savannah, Francine, Francen. And if it wasn't stated before by the previous judge, there's an affirmative finding of family violence. Court will deny the motion and terminate you on set. Is there anything else from either side?
Nothing further from the state, Your Honor.
That's the twist no one expects. She acknowledges the mistake, but she doesn't destroy his future for it. Instead, she gives him something rare in court, a
I
second
don't
chance.
have to answer to the obligations. Part of drug treatment is making amends. And part of making amends is making amends to people that you've entered into contracts with. You understand? The only reason why I'm terminating you on set because these allegations are from 2020. According to the probation report, it shows that you've done everything that you were supposed to do on probation. Yes, you owe some court fees, but it's not due to restitution. Are we off the record? Okay, I just want to make sure. All right. With regards to your child, you know the people who have your child.
Yeah.
Sometimes in CPS cases, strangers adopt children and you don't know who
know.
have them.
I know.
So you need to straighten out your life. I don't know what your relationship is with your in-laws or what's going on, but I do know that sometimes if someone has a child who was with you, right? And they are not the child their parent wanted to be, sometimes the parent blames the person who was with them. So you need to better yourself. And maybe if you get your life together,
And this is bigger
100%.
than just one case. Because what she's really saying is, you don't just fix your life by staying out of trouble. You fix it by taking responsibility for everything you broke along the
Counts for the
way.
record for the state
Hank Wilkins for the state, Your Honor.
defense.
Ruben Pisania for Mr. Caballero.
And are you Christopher Caballero? You need to unmute.
Okay, yes, ma'am. Christopher Caballero.
All right. And I'm going to place you on mute. Your client is appearing by Zoom. Any objection from the state
No objection, Your Honor.
and defense? I'm assuming you have no
No
objection.
objection, Your Honor.
And Mr. Caballero, if you could unmute again, please.
Okay.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Christopher Ryan Caballero?
All right. Do you have any objections to appearing by Zoom?
No.
All right. And you understand that you do have the opportunity to appear in person in court?
Correct.
All right. Thank you. All right. We are here for a motion to return of seized property. And the property that the defendant is asking be returned is a loaded Springfield Armory XD 9mm handgun with 1 magazine and 12 live rounds. A Saiga SAIGA 7.69mm rifle with 1 magazine and 10 live rounds. And those are the weapons that you're asking to be returned, counsel?
Yes, Your Honor.
And you're not asking for the magazine to be returned, are you?
Not the live ammo, but the magazine and the weapon.
So you're not asking for any of the live rounds?
No, Your Honor.
All right, we previously had a hearing on this, and I asked everyone to review any case law because I don't think your client should have these weapons back. But I know what the law is, and of course, I will always follow the law. I think it's odd that someone has a drug case and now he's concerned about some weapons. And I don't even think these weapons are antiques or some weapon that you can't find everywhere. Is it just the expense? Why does he want these weapons back?
Yes, Your Honor, just because he did purchase them legally under his name and they are his property. They're relatively valuable, probably.
Now this is where things get interesting, because even the judge herself doesn't agree with what might happen
Your Honor,
next.
I believe, is there some case law you had?
Yes.
So I believe the defense has some case law that he cited in his motion. I was unable to find any case law that says that to cite to bring before the court today. It is our policy to oppose these types of requests to get weapons back, Judge. And there was a version of the defense motion that requested the weapons be returned to defense counsel rather than the defendant himself. So we would request, if you were going to order the weapons be returned, that they be returned to defense counsel rather than the defendant, Judge.
Do you want them returned to you?
Your Honor, if that's what the court wants, as long as the court allows for us to then return them to him.
No, I mean, it's just either yes or no. Do you want the weapons returned to you or do you want them returned to your client?
To my client, Your Honor.
All right, so the court has reviewed case law. And under Article 18.19 about seized weapons, if you all want to review it and look at it, it says, weapons seized in connection with an offense involving the use of a weapon or an offense under Penal Code, Chapter 46, shall be held by law enforcement agency making the seizure subject to the following provisions. Unless the weapon is a prohibited weapon identified in Penal Code, Chapter 46, and Chapter 46 has to do with all weapons offenses like unlawfully carrying, or the weapon is alleged to be stolen property. So the first question is, Do you have any documentation that these weapons are his?
Your Honor, I did ask my client, he said that it may be possible for him to procure a statement like either bill of sale or receipt from when he purchased the weapons. But he did say he purchased them himself, so they should be under his name.
All right, so one, that's what the court is going to need to show that these are actually his weapons. All right. Now, the other thing, if there is no prosecution or conviction for an offense involving the seized weapon, the magistrate to whom the seizure was reported shall, before the 61st day after the date, the magistrate determines that there will be no prosecution or conviction, notify in writing the person found in possession of the weapon that the person is entitled to the weapon upon written request to the magistrate. So he's already requested it back. D, a person either convicted or receiving deferred adjudication under Chapter 46 is entitled to the weapon seized upon request to the court in which the person was convicted or placed on deferred adjudication. However, the court entering the judgment shall order the weapon destroyed or sold if the person does not request the weapons before the 61st day, which he has. The person has been previously convicted under Chapter 46. So I need to know whether or not he's been previously convicted under Chapter 46. The offense for which the person is convicted or receives deferred adjudication was committed in or on the premises of a playground, school, video arcade facility, or youth center, as those terms are defined. So I don't know, because this is a pretrial diversion. I don't know where he had the weapons. Or the court determines, based on the prior criminal history of the defendant or based on the circumstances surrounding the commission of the offense, that possession of the seized weapon will pose a threat to the community, or one or more individuals. Here's the issue. It has to be a conviction or receiving deferred adjudication. He wasn't convicted. He didn't receive deferred adjudication. So if he provides proof to the court that these are his weapons, either through a bill of sale or some other documentation that the court can view, I am obligated legally to return the weapons to him. Do I think the weapons should be returned to him? Absolutely not. Do I think it's odd that he received a pretrial diversion for a drug case and he's concerned about weapons? That should be the least of his concerns. But legally, I must return the weapons. So I will return the
And
weapons.
this right here is the reality of the justice system. Sometimes it's not about what feels right. It's about what the law requires. And that gap between law and justice, that's where things get uncomfortable.
And that's the case law or the statute that the court has seen. When he provides the bill of sale, if he can, if somebody finds some new case law or something new happens, you can always let the court know. We can go off the record. But as it seems here in Texas, they're even close to passing a law where people who violate protective orders, that they can have their weapons back. And I think we're going to get to the point where even if you have a domestic violence case, I think the government, the Texas legislature is looking at even giving them weapons back.